Yes, Mr.
My lady, I wonder if I could start just addressing the question of the nature of the hearing. It's a question that your ladyship asked of a learned friend. I took instructions over a short adjournment and outline. I am told as follows. Firstly, in terms of the lengths of the hearings, they are typically short. I am told typically around about an hour.
Right.
So they are short hearings. Secondly, in terms of attendance, the director himself attends, and he may ask some or all report writers to attend and to be involved in the process. He also, I'm told, normally does have a senior psychologist in attendance as well, assisting him. So that's somebody who, as I understand it, has not previously been involved by preparing a report, for example, prior to the LAP recommendation. The process is generally an informal process with the director leading the questioning. There may also be questions. He may ask the psychologist to ask questions of the prisoner, and also the lawyers for the prisoner are able to attend, and others, for example, I understand typically the offender manager, so the prison-based probation officer. Well, I hope that assists.
That's most helpful. Thank you very much indeed. Presumably you passed all that information over to Mr. Rule.
I hadn't. I'm sorry. I had only got it very shortly before I came in. Apologies for that.
It may be appropriate for me just to add to that the instructions I took, which are consistent really with what you've been told. I spoke to someone on the advocate side who's conducted 4 of them. He says the room can be between 4 and 15 people. That you have Steve Easton there, as well as Richard Vince, who is the deputy director who takes the decision and asks the questions. He is accompanied by a psychologist who has sometimes been the head of psychology at the MOJ, so that concurs with what unfairness said as well, unrelated to the report writing, as another panel member. Witnesses have included the governor, including the #1 governor of the prison, and POMs and psychologists. And typically, at the end of the hearing, everyone's asked to leave, and actually decisions are often promulgated, I understand, at the end of the hearing.
Thank you. Well,
So
thank you both for, I hope you each managed to get a sandwich in and around your inquiries. Thank you.
May I just ask a follow-up question, please? You said, Mr. Owen, that the prisoners' lawyers are present. Are they allowed to ask questions, or are they just present?
I think that's not a point on which I have
Okay.
had instructions. I will, of course, do so if that's assistance, and then a friend may be able to help.
My instructions is they do ask questions.
Right.
Although I was told on one occasion their presence in the room was forgotten, and they weren't asked to ask any questions. But in fact, when the decision was announced, it made no difference because it was favourable. Okay. But typically they participate.
Okay,
Thank
that's
you.
helpful. Thank you.
A great friend. Ladies and Lord, I will address matters, as I indicated before, in the same order that friend did. So first of all, touching on the policy issue as far as the submissions prior to the between the LAP recommendation and the decision. And my submissions on this can be very short because they amount in essence to saying respectfully the judge got it right, and he sets out his reasoning at paragraphs 85 to 87 of his judgment. I don't ask that the court turns that up now, no doubt it's familiar. I make the following brief additional submissions. First of all, it is worth noting that elsewhere in the PSI there is specific provision made for time periods to allow submissions by the prisoner in response to documents. So for your notes, paragraph 4.20 of policy PSI allows 4 weeks between delivery of the dossier containing the reports and the LAP meeting, so that the prisoner has the opportunity to make submissions in the intervening period, and there's also provision for that period to be extended on request. So simply as a matter of construction of how the policy operates, respectful submission, that's material. If it would assist the court, then we can turn it up, but I don't propose to go beyond simply saying that is a part of the policy development. As far as the difference between italicised and non-italicised text is concerned, I may respectfully agree with my Lady Justice Elisabeth Laing as to the contrast between instructions and guidelines. To follow up with the submission that there is no reason why a policy cannot include both or either, and indeed that the provisions at paragraphs 4.6 and 4.7, which we'll come to in due course, are a typical example of where that distinction is in fact clearly of assistance to creating a policy which in some places is mandatory, in other places is clearly giving guidance or indications about how to proceed in the appropriate context. Ladies and Lord, unless there is anything else on that ground, I'll move on to the procedural fairness ground, the common law procedural fairness ground. On this point, if I could perhaps deal with a slightly more general point that submission that ran through my learned friends' submissions, which was to the effect that the judge failed to have regard to the need for him to come to a conclusion about what procedural fairness required. And on this, I wonder if you could be kind enough to turn up page 48 of the core bundle, paragraph 103 of the judgment. At the very bottom of page 48. I respect the submission of the judge there. Makes it absolutely clear what he's doing, which is that he is deciding what procedural fairness requires on the facts of this case, and he has agreed with the Secretary of State's case on that. So he is taking an independent view. It's just that he happens to agree with the Secretary of State made for the effect of the Secretary of State submissions. And as to his analysis, that is set out primarily at paragraphs 107 and 108. Of course, that builds on the earlier analysis that he did of the process. And again, with respect, I agree with the judge. My respect to submission is that the judge has got it right there. But essentially, there's two elements to his conclusion that procedural fairness did not, on the facts of this case, demand the opportunity to make submissions between the LAP recommendation and the decision. The first of those is that the matters which are identified by the appellant as being matters upon which he wished to make submissions were in fact immaterial to the eventual decision. And secondly, that in any event he had the opportunity after the decision was taken to make submissions which would, if it was necessary to do so, allow any error to be corrected. And on both counts, my respectful submission, he is correct. On the first point, as to the materiality of the matters upon which the appellant said he wished to make submissions, there are 2 points that are identified. The first is the bullying allegation. The court has already been taken to the decision from the 19th of January, and it may just be worth turning that up briefly again to see how the bullying allegation is dealt with while I make the submission. It's at page 153 of the core bundle. And this is the decision from the 19th of January, and the reference to bullying is the penultimate paragraph on that page that begins the category 18. And that first sentence, my respectful submission, shows what category 18's true analysis was, which is that the behaviour has been satisfactory. Some alleged negative information, including possible bullying, so even the description of the evidence tends to weaken the content. And it says, receive no recent adjudications, continue to make good use of the regime. And then the third sentence, again, in a sense it speaks for itself, general regime adherence. So what the LAP is, what the CART is in fact finding is that he's been compliant, and there's no material weight placed on the bullying allegation at all. It's mentioned, but it's not relied upon. The other matter that is raised is by the appellant in his skeleton argument, this is paragraph 31 for your note, is the reference to the PCLR test. This is the test for psychopathy had been recommended in earlier psychologist report, I believe in 2018, but the court will recall that both Dr. Pratt and Ms. McGraw agreed that it was not in fact necessary. The lap minutes, again, I don't think it needs to be turned up, but for your note, it's at pages 89 to 90 of the supplementary bundle, contain an inaccuracy in that they refer to the PCLR test having been completed. In fact, it hadn't been completed. What had been completed is the HCR 20 test. But staying on page 153 to 154, there is no reference in the letter, the decision that's first decision under challenge, to the PCLR test at all. And there is no sign whatsoever, the reference to a PCLR test having been completed played any role whatsoever in the decision that the court took. So it is immaterial. Therefore, the judge was correct to find that those matters were not material. As to the opportunity to raise post-decision submissions, again, it's clear that that opportunity was taken and it was responded to substantively, as you can see from the March decision that's at page 155. And my learned friend says that a post-decision submission is not an adequate safeguard, to put it in short terms, and he relies on, for example, Balajagari and other minded to situations. My respectful submission is that that is a comparison which really assists the court not at all. The first point, or the first place to go, if I may respectfully suggest, is to look at the part of the policy, PSI, which provides for post-decision submissions, and it's in the supplementary bundle, the PSI, and it's the very final paragraph of that PSI, 124 of the supplementary bundle. Under the title Post-Decision Process, Category 18 will consider and respond to representations against a decision to keep a prisoner category a restricted status. The Director of High Security or Deputy Director of High Security or Delegated 3 may retake the decision where he considers that the representations highlight information not previously considered that could materially affect the decision. So in other words, if there is some information, and that's not simply restricted to evidence, but information which materially affects the decision and hadn't been considered previously, then it's open to the CART to retake the decision. And of course, that's a power or discretion that will have to be exercised in accordance with usual public law duties. So if, for example, there had been a material error in the LAP recommendation, but that material error had not been included in any of the documentation that had previously been disclosed to the appellant, then he could have raised, by way of fresh information, the fact that there was an inaccuracy there. Can I briefly then take you to Balajagari, and bearing in mind the nature of the opportunity to seek a review under the PSI, the situation, the position under in Balajagari is very different. So it's in the authorities bundle, and the relevant part is at page 407 of the authorities bundle.
Tab 15.
Yeah, 15 is correct. Yeah. The learned friend took you to paragraphs 58 to 60 of the decision in Balajagari, but not to paragraph 61. And that's crucial, because what paragraph 61 does is describe the nature of the administrative review opportunity in the context of Balajagari. And critically, what it makes clear is you can't put any new material before the decision maker that wasn't before the original decision maker. And it's, in my respectful submission, accurately described towards the end of that paragraph as a limited type of legal review, which is clearly inadequate, precisely because the applicant had no notice of the Secretary of State's concerns, he or she had no opportunity to put evidence before the original decision maker. It could not be more different. May I briefly add as well, my Lady Justice Elisabeth Laing asked about the facts of Balajagari, and those are material as well, because I may be doing violence to the details of them, but in essence, what happened was people made applications for long-term leave to remain, having been in the United Kingdom for significant periods of time. They were asked to submit details about their earnings as part of the application for leave to remain. The Secretary of State requested tax information from HMRC and then made decisions where there was a difference, there appeared to be a difference between the information provided by the applicant for leave and the HMRC. Effectively, the Secretary of State took an adverse inference from that difference without giving the applicant the opportunity to comment on it. Again, if I may say so, could not be more different from the kind of process that is before the court today. So, unless there is anything I can assist you on further in relation to the common law procedural fairness issues under ground, what's pleaded as ground one, but the second ground is addressed, those are my submissions on that. I'm grateful. Moving on then to oral hearings, I will try to accelerate to some degree the submissions on this on the basis that the court has already had reference to paragraphs 4.6 and 4.7 of the policy. Simply to make the following submissions, which I don't think would be controversial. First of all, the paragraph 4.6 of the PSI gives a clear direction for open-mindedness and a fair-minded approach to considering whether on each case there is a need for an oral hearing. In fact, if I may ask that the court briefly turns that up. It starts at page 119 of the supplementary bundle, and there is a considerable amount of commentary there about different cases and their the effect of them. But on the following page, at the top of page 120 of the supplementary bundle, it makes the key point that each case must be considered on its own particular facts, and that's a mandatory direction. And then gives, again, at the second bullet point, a mandatory direction to consider in an open-minded way whether or not there is an advantage for an oral hearing in a particular case. That is the context in which the guidance is then given in paragraph 4.7. So just going back, if I may briefly, touching on the value of the distinction between a mandatory instruction and guidance, here, somebody operating this policy is clear that it's mandatory that they give open-minded and fair consideration to whether or not an oral hearing is necessary. And then paragraph 4.7, as my Lord identified, is a set of instances that would tend to favour an oral hearing being appropriate. And that is the effect of 4.6 and 4.7. Just to draw particular points out of those paragraphs at 4, or the instances at 4.7, 4.7a gives an example of where facts are in dispute, and it goes to emphasises the importance of the facts, whether they go directly to the issue of risk. So, of course, always bearing in mind the governing question that the director has to have in mind, or the CART has in mind under paragraph 4.2 of the same policy. And then also giving guidance that it's really a question of whether or not an oral hearing is required to resolve that issue. A similar point is made at 4.7b. Again, the passage speaks for itself, and no doubt the court will have regard to it, but simply to highlight that the second sentence need to be considered with care in order to ascertain whether there is a real and live dispute on the particular points of real importance to the decision. So the question is not simply whether there's a dispute, but whether resolution of that dispute is necessary or is of real importance to the underlying decision relating to paragraph 4.2, and of course whether an oral hearing is necessary to deal with that. Just again for the court to note, in Hassett at paragraph 66, the court confirmed that paragraph 4.7b, and specifically the second sentence of 4.7b, was not unlawful or misleading in a Gillick sense. So that's a point to note in there.
But even where there are particular points of real importance to the decision, what the decision maker is told that a hearing might well be of assistance to deal with them. So the decision maker isn't told you must have a hearing in that situation.
No, absolutely right, Millie.
It's an indicative factor.
It is indeed. And perhaps to anticipate to deal with the submission that a friend made, the fact that these are not mandatory does not mean, of course, that the Secretary of State, in taking a decision about an oral hearing, is entitled to ignore them. It's never been the Secretary of State's submission in this litigation either, with respect to paragraph 4.6, 4.26, or 4.7.
The whole point about 4.7 is it's setting out potentially relevant considerations for the decision.
Yes. And potentially relevant considerations which may well capture many of the potential reasons why an oral hearing is required.
But it's not dictating the outcome.
So again, without dwelling too long on the policy, that those, in my respect, submissions, in my respect, submission, it is a fairly clear structure of some mandatory points taken then with indicative guidelines. The question then of when an oral hearing is required as a matter of procedural fairness of common law, the learned friend has taken you to various authorities, and they are also referred to fairly extensively in certain arguments, so I won't repeat those. However, could I briefly ask that the court turns up the case of Mackay, specifically paragraph 28. Of Mackay, it's I don't have tabs, but it's tab 5, and in terms for the pagination, it's page 51. It begins on, and the guidance given at 28 is now familiar, or is familiar, particularly when one has had regard to the policy recently, and none of it is surprising. The decision needs to be on the basis of particular facts. It's no requirement for exceptionality, and so on. The purpose of turning this up is simply perhaps to aid on one point, which is on page 53, which is part of still paragraph 58. My Lady Justice Elisabeth Laing asked about the question of impasse.
Sorry, it's paragraph 28, I think, isn't it?
I do beg your pardon,
Yeah,
Milady, yes,
sorry.
paragraph 28, yes. Paragraph 28, Roman 3 on page 53.
Yeah.
Just to draw your Lordship's attention to the fact that there are two examples of impasse given there, one of which I think the learned friend perhaps had in mind when he answered your question as part of an intervention, and for what it's worth, I respectfully agree, impasse is not a
Yes, I
term of
see.
art,
That's
may
really
come
helpful.
about in different
Thank you very,
ways.
very much for that.
I would also then respectfully draw the court's attention to Roman 4 just below, just to serves to emphasise a theme which runs through all of these decisions. Not to say it should not be thought that the mere existence of an impasse or inconsistency means that an oral hearing will be warranted. And then also giving guidance, the court should not be too ready to conclude there is an impasse or even an inconsistency when there may not be any more than simply a difference of view for very good reasons. And with no surprise to the court, in my respectful submission, that's precisely the facts that you have here. You have a difference of professional view between two psychologists, not an impasse, and certainly not something which warrants an oral hearing to resolve it. Just remaining with relevant authorities, if I may ask again briefly to turn up Hassett, which is at tab 1313. The court, I think, has already had reference to paragraph 51. I don't ask that you turn that up again now, save to note that it is plainly highly material. but the relevant, the key parts that I respectfully say need to be borne in mind start at page 323. This is in addition to para 51, which is of assistance. Page 323, paragraph 60 at the very bottom of the page. This is where Lord Justice Sales contrasts the difference between, or emphasises the difference between the procedural duties for the parole board and those for the cart. His conclusion to paragraph 60 is on page 324, begins, however, towards the top of the page. No doubt the case that the cart director could not lawfully refuse an oral hearing on these grounds, that is to say, on the grounds of saving time, trouble and expense. It is relevant consideration in assessing whether it does need one, and that the courts should be careful not to impose unduly stringent standards liable to judicialise what remains, and in essence, a prison management function. And then paragraph 61 says, again just towards the bottom, fairness will sometimes require an oral hearing by the cart, if only in comparatively rare cases. In particular, if asking the question whether upon escape the prisoner would represent a significant a risk to the public, the cart, having read all the papers, were left in significant doubt on a matter upon which the prisoner's own attitude might make a critical difference, the impact upon him of a decision to maintain category A would be so marked that fairness would likely require an oral hearing. So again, the importance to the importance or centrality of any issue of fact or opinion to the test under Rule 4.2 is the guiding light in Hassett as well as in Elisabeth's version in the cart. Final reference in Hassett, if I may, is on the following page at page 325. And again, this is paragraph 69 by the bottom hole punch in my version. Even in a case where there is a significant difference of view between experts, it will often be unnecessary for the cart to hold a hearing to allow them to ventilate their views orally. This might be so, for example, there is no real prospect this would resolve the issue between them with sufficient certainty to affect the answer to the to be given by the cart to the relevant question, and fairness does not require that there should be an oral hearing on the basis of a speculative possibility that that might happen. And he then cites the case of Downs, paragraph 45. Downs is in your bundle, I believe, at tab 3. It's at page 70 of the authorities bundle. And essentially, to summarise the effect of the judgment of Justice Aikens, what he says in essence is, on the facts of the case, there were two experts who had clearly expressed their views.
Sorry, I've got a wrong reference here. Downs is where?
I do believe it's tab 6. I do beg your pardon. Really.
Ah, that's why I couldn't see it at tab 3
No,
then.
do forgive me.
Thank you, tab 6.
I'm having the same problem.
Got there in the end.
I've
Thank you.
lost it. What have I done with it?
It's paragraph 45, page
Paragraph
70 in the bottom right hand
Thank you.
corner.
Thank you.
And again, you have a finding there which is similar to the to the finding of Justice Sales at para 69 of Hassett. In essence, the court identified that there were two experts who had different opinions, but that those opinions had been clearly expressed in reports and were therefore available to the cart. And it was clear that notwithstanding the difference between those experts, it would need an oral hearing to perform that process of deciding where the the answer to the question under Rule 4.2 as it now is. So those last two references, in my respectful submissions, paragraph 69 of Dan's and to paragraph 45 of Downs, paragraph 69 of Hassett, in my submission are on their own a complete answer to the Laing friend's case with respect to the what he now says, as I understand it, is the test for an oral hearing. He says, I don't want to do violence to his submission, but in essence, that even if there is a possibility of a different outcome, that in those circumstances, bearing in mind the importance of the decision to the individual concerned, and possibly the obligation not to prejudice or to decide, prefer one particular report over another, that in those circumstances, if there is a possible different outcome, the court should convene an oral hearing. Because that is effectively directly contrary to paragraph 69 of Hassett, where speculative possibilities are not a good reason for an oral hearing, or to put it conversely, where the possibility that an oral hearing will result in a different outcome is no more than speculative, an oral hearing is not required. Ladies and Lord, if I may then move on to specific responses to the grounds they're pleaded, or as they're set out in the Sheldon argument. The first is ground 3, which is the contention that the judge did not appreciate the seriousness of the decision. I've dealt with that in my Sheldon argument and responded to it. I say that to the extent that relies upon the contention that he didn't take an independent view of what procedural fairness requires, paragraph 103 shows that's wrong, and unless there's anything else I can suggest, I don't propose to address further on that. As to ground 4, I must confess I'm slightly surprised that it's now said that there is not a new test that is being proposed. Certainly when one examines paragraphs 47 and 48 of the Laing friend's Sheldon argument, it appears that there was such. But as I understand the submission as it's advanced today, it boils down to, I don't want to be repetitive of what I've just said, but it boils down to a suggestion that the decision around an oral hearing should not take into account the likely outcome of that hearing or the possible outcome of that hearing, rather should have regard instead to questions like the importance of the issue to the prisoner.
It clearly has to have some benefit. That's not to say you have to be able to demonstrate the outcome, is my note.
Well, of course I accept that it's impossible for anybody to predict what the outcome of an oral hearing might be. It's always possible that something new might come up. However, bearing in mind the guidance that's given in Mackay, in Downs and in Hassett, my respectful submission is that it is plainly right that when deciding as a matter of common law fairness, in this particular circumstance, whether an oral hearing is required, a guiding light in that is whether, number one, there's any real prospect that particularly professional differences of opinion are likely to be resolved. Number two, if they are resolved, whether, in fact, there's any real prospect that the test under 4.2 will be found to be met. Bearing in mind that that establishes a high threshold for evidence that's required. So to take an example like this one, there are some differences of opinion between the experts, as almost always is the case. Set out in my Sheldon argument why I say those are not in fact as significant as in many other cases, but they exist. But as the judge correctly identified, whilst Dr. Pratt himself did not think that the Identity Matters programme was the appropriate programme, he still thought that there needed to be significant work done by the appellant before he, on his own recovery, albeit in the therapeutic community. The evidence of Dr. McGraw was that there was the need for the Identity Matters programme, and she raised a series of concerns in her report, some detail about what was happening. And so it's very difficult to see how, on the best case scenario, if I put it this way, as far as the appellant is concerned, how the director or the cart would be satisfied following an oral hearing that the high threshold in paragraph 4.2 was met. And so this is, if I may say so, a typical case where, notwithstanding a disagreement, albeit a comparatively narrow one, between the experts, an oral hearing is certainly not required for fairness purposes in order to resolve that. So on the facts of the case, my ladies, my lord, an oral hearing is not required, and to the extent that the learned friend suggests that there needs to be some lesser weight placed on the importance of the potential outcome of an oral hearing when deciding whether an oral hearing is required, in my respectful submission, that is wholly inconsistent with Hassett and with the other authorities. And I would add, it's also inconsistent with policy, and there is no challenge to the lawfulness of policy. If the learned friend is right about what he says, then it's rather difficult to see how the policy would not be misleading in a Gaelic sense. And so, in my submission, that's not something that can be pursued. Again, ladies and gentlemen, I don't want to be repetitive either of submissions I've already made or with matters of concern and argument, which I trust is comparatively clear on ground 4 and response. Is there anything else I can assist on that?
Not for me.
On ground 5, which is in relation to Zaman and Sequins, once again, I set out fairly full submissions in my skeleton argument. The headline submission on that is they are decided in their facts. They are expressly applications of the principles in the trilogy of Court of Appeal cases to which we've had reference, and so they really take matters no further. Ground 6, I'm not sure my learned friend advanced that in his oral submissions, but again, that's a matter that's dealt with in my skeleton argument. Essentially, it's a series of submissions that rely upon his contentions under ground 4 as to the proper test to be applied. And again, unless there's any particular points on which I can assist the court, I won't take them further.
No, thank you.
And then in relation to the case-specific points, which is ground 7 to 9 of the learned friend's skeleton argument, once more, I don't want to take matters any further than necessary, but simply to say that in my respectful submission, the judge was correct in his analysis on those. In the skeleton argument, I have dealt in some more detail with why I say, essentially the point that I've raised in response to ground 4, that whilst there are differences between the experts in particular, they are not matters which are likely to be resolved at oral hearing. The CART had access to the reports, was able to identify the differences between the experts, and so in those circumstances, the oral hearing was required under the provisions of paragraph 4.7 in particular of the policy. Again, unless I can amplify those on any particular points, then I will simply rely upon the case set out in the skeleton argument.
Thank you.
Thank you. May I very briefly turn my back?
Please do.
I'm great. Unless there's anything else.
Anything else? No, thank you very much indeed, Mr. Owen, most helpful. Mr. Rule, anything in reply?
Very briefly, you asked me to do what I could to ascertain the factual position earlier in relation to HCR 20s. I am now reliably able to confirm that for the current review that we don't know we know the negative outcome, we don't know the content of.
Right.
There was no assessment. For the previous review, which is under active judicial review, with permission having been granted, there was a further assessment, which goes back to January 2023, which would be an HCR 20 similar document to that which Ms McCraw produced.
Thank you.
So that illuminates matters that at least is factually
Thank you
the
very much.
accurate
I'm very
position.
grateful, Mr. Rule.
Regarding the question of policy, there were some questions earlier to myself in relation to the terminology used, and the only immediate research that I could avail myself of is from the way in which it's described in the A and SSHD Supreme Court decision, because we have that in our bundle at tab 18.
Do you want us to turn that up?
My lady, it may be just to help just to show you where I see reference. What I was looking for was any particular definition of policy. One doesn't see that, but one does see some expressions of it. So that's our tab 18 of the authority.
Yes.
And the back background, of course, is that this case was heard alongside the BF Eritrea case, the two different pieces of policy or guidance that were being challenged. We don't have the other case in here, which concerns guidance to Home Office officials on age assessment, but we do have this decision, which refers specifically to a particular guidance. So on pages 484, at the beginning of the court's judgment, paragraph 1 referred to the contents of a policy document or statement of practice. So it didn't limit it to what might be termed a policy document, but also a statement of practice. And then, of course, the particular policy in that case was one which was giving guidance or described as guidance. And in paragraph 2, towards the middle, it's policy documents to give guidance about how the powers may be used in practice. And then at paragraph 4, you see that the guidance in that case was guidance, particularly in relation to child sex offender disclosure scheme guidance. I can't draw very much from it, but I just drew attention to it because obviously it's a policy challenge case. The interesting point perhaps is that some of the cases considered were more systemic challenges, so that the policy or practice could be a systemic practice that was being challenged on the basis of unlawfulness, which is considered towards the end of the judgment in relation to other types of unlawfulness, where you have, for example, a system that had inherent unfairness, as discussed in Tabak and Refugee Legal Centre, which is a slightly different species to the usual policy considerations of lawfulness, which are paragraph 46 and the three options there. But just if one just turns to the very last paragraph, you see the reference to the other types of unlawfulness there might be, one of which is the inherent unfairness in the system scenario. And that might, of course, not strictly be a policy statement or even a guidance statement, but more the way in which the authority carries out its function. But I don't know if that helped very much, but it was the only reference that I could immediately see on that. What I would submit is that there isn't anything that the respondent has been able to show you which suggests that there is a terminology or a description that the authority can use for its policy or guidance that provides any distinction in public law terms.
Well, I'm sorry to say I just don't understand that submission. I mean, it's important to bear in mind that the issue in A seems to be described in paragraph 23, and the issue was that the appellant was submitting, was it the appellant, maybe it was the respondent, was submitting that the guidance didn't go far enough in giving advice to decision makers about what they should or shouldn't do. So it's a completely different point. He says, last sentence, Mr. Southey submits the guidance as unlawful because it gives rise to an unacceptable risk of unfairness. So, I mean, all I'm saying is that A was about a very particular type of issue, which is whether or not guidance is unlawful because it gives rise to a risk of unfairness.
Yes, in general terms, the court rejects that as being the test. The dicta on the usual test, I think, is paragraph 46.
But I'm not sure really what you get in this case. Speaking for yourself.
Well, my lady, it's not specifically on the point what amounts to policy, or does certain type of policy not have the lumbar mandalia traction? But my submission is that there isn't a distinction on the policy that's under challenge in this case to say that on the policy or guidance to say that it is defined in a way that excludes it from the operation of the public law principle that I've sought to rely on. I don't think it takes us any further than you've seen. I'm sorry, it doesn't.
Not at all, thank you. So that's policy.
That's the policy. The question of the policy itself on 4.6 and 4.7 on the oral question point, the court has seen that, and I don't ask you to go back to it, but you'll have noticed in 4.6 there was a recognition that there were likely to be more oral hearings applying the policy than there had been hitherto, and that is in consonance with what is recognised in the post-Osborne Hassett dicta as well. That having been said, of course, there were oral hearings required since the case of Williams and H, which had decided at common law that there were requirements for oral hearings in certain circumstances. And I don't ask the court to go to it now, but I do invite the court to give full regard to the policy terms, which my learned friends' submissions rest upon it being guidance that provides considerations, and I fully accept its guidance providing considerations that have to be borne in mind by the decision maker. But we submit that when one reads what those considerations are, they're expressed to recognise when an oral hearing is necessary, because it does add value to deciding something which rests on the attitudes or of the individual being assessed, or on exploring disputes between experts which are capable of resolution or capable of informing the decision maker, and providing for the benefit to which the policy refers and to which the common law authorities have referred. So the suggestion on the facts from learned friend was that even with Dr. Pratt, there's discussions of further work. Well, of course, this is category A. We're not talking about a prisoner ready for release, but we are talking about whether he's made the progress to demonstrate the insight and the skills that satisfy 4.2, or potentially do so if he's given the oral hearing to resolve issues and determine the position. And Ms McCraw, as you saw in my submissions earlier, did say on the basis of the insight and the work that he's demonstrated, he could be considered for downgrade. So that's the basis of the factual position we've reached. It is not one which doesn't meet the test of being likely to resolve issues of relevance that go to the issue of risk, that go to the question of whether or not there could be a downgrade.
Can I just see whether I understand your submission, Mr. Rule? Are you saying that on the facts of this case, the PSI dictates that the decision maker must hold an oral hearing?
But let me be very, very careful. I submit as an application of the facts to it, the only correct outcome is that an oral hearing is required. But what I do accept is that what it sets out is not a mandatory list of any kind, but it sets out the relevant considerations. It's only in the application of those to the facts.
I just need to take notice. I just want to unpack that. So you accept that the policy does not in terms dictate the result in this case?
Yes, it doesn't dictate that any particular consideration must result in an oral hearing. Absolutely.
Right. But you go on to submit that on the facts, the only lawful answer that could be reached is that an oral hearing was required. Is that right?
Yes. Although one might say should be reached, because of course it's the question for the court assessing those facts.
All right, well, let's not worry about that at the moment. I'm just trying to understand the basic submission. Thank you.
I noted it down this way. Applying the facts to the policy, the only proper outcome was to order an oral hearing.
Yes, I did that. That is the essence of the submission.
I think you apply the policy to the facts, possibly, don't you, rather than the other way around?
I'm sorry, my lady.
Well, don't you apply the policy to the facts rather than the other way around?
Yes, as a matter of approach, one does. But of course, without the facts, the policy application would lead to there not being an oral hearing, because I wouldn't have the factual basis for the policy being satisfied, or the factors the policy identifies being present.
Thank you, that's very helpful.
Unless there's anything further.
No, thank you.
Oh, actually, there was one further. Can I just raise a general point? I sort of made the mistake of looking at the Prison Act, and there are a couple of, to me, slightly mysterious provisions. Section 1 and Section 4.3. It's not in the bundle. Sorry, I've made a mistake of doing my own research. I was just wondering if it might be possible for you to agree a note about what, in general, the powers referred to in Section 1 and 4.3 of the Act are. because both sections assume various powers, pre-existing powers, and I have no idea what those might be.
Lady, we'll certainly look at that, but I have to say, on my feet, I
No,
can't
I'm not
offer
asking
any
you to.
assistance.
I'm assuming that you won't be able to answer it on your feet, which is why I'm asking you both to see even if you know about what those powers are.
What I think we can assist with, and it may even be in this judgment, there is quite often reference to the power in the Prison Act 1952 for the Secretary of State to confine a prisoner to any prison. Which I think is section 12.
That's not the point of my question at all.
Is this to do with the?
This is to do with the explicit references in section 1 and 4.3 of the Act to powers, which are described there, but which I simply know nothing about.
Perhaps if you could agree a note, that could be sent in the first instance to my clerk.
Essentially, they're references to pre-existing, powers that existed before the enactment of the 1950 Act. I'd just like a general idea of what those powers are.
Well, thank you both very much indeed, and there's sitting behind you for all the preparation and hard work that went into this appeal. You won't be surprised to hear that we're going to reserve our judgments. We will send through a draft judgment in due course. In the normal course of events, that is for typographical and other minor errors only, and not an opportunity to re-argue the case. May I remind you all of the terms of the embargo that appear at the top of any draft, and there must be rigour in consideration as to who has an opportunity of considering the drafts. We'll hand down the judgments in the normal way electronically in due course. Perhaps if there's any outstanding matters that you can't agree, we'll deal with them on paper. Otherwise, we'd be grateful if you could agree an order in due course. Thank you all very much indeed.
Court rise at table.